Hello, everyone, and good late morning, and good evening and good afternoon to those who are joining online. Thank you very much for making the time to join us for this discussion. As Sophie mentioned, the title of my talk is about making rights matter in post-pandemic reforms, and the starting point of it is really that. That international legal mechanisms are perhaps failing us in terms of integrating lessons learned around human rights-based approaches to pandemic responses. These are not new lessons, I have to say. What we've learned from COVID for 3 years is not new. We've learned this as well with the HIV pandemic. We've learned it with Ebola. We learned it with Zika. We've learned it with many other outbreaks that have rattled us as humanity. But what we need to think about, I think, as we move forward in this moment is whether international law is the answer, and if it is, how we can leverage it to be able to respond, to be able to create equitable frameworks for governing pandemic prevention, preparedness, and response. So much of what I'm about to share with you is drawn from the Principles and Guidelines on Human Rights and Public Health Emergencies, which were launched in May of this year on the sidelines of the 76th World Health Assembly in Geneva. Now, the principles are a joint initiative between the International Commission of Jurists, which is a world-renowned international NGO that has promoted the rule of law and human rights since the 1950s, and the Global Health Law Consortium, which myself and many others are a part of, which is a network, essentially a research collaborative of scholars from around the world whose work intersects at the point of health law, international law, and often human rights. The principles, which I'll get to in a bit later, were the result of a 3-year consultative process between academics, civil society representatives, practitioners, and what they aim to do was really provide a progressive interpretation of international law as it relates to rights-based approaches to public health emergencies. Just as a minor point of housekeeping, I should mention that throughout my talk, I'll be referring to the Principles and Guidelines on Human Rights and Public Health Emergencies as simply the principles. They're just a mouthful to be saying them over and over again. And while we wait for the branded version of the principles to come out, they are accessible right now at a tiny URL link that is up on the slides, and I'm happy to also post it in the chat later. They are finalized, they are ready for dissemination. It's just that at this point in time, while we wait for the website and branding to come forward, this is where they are temporarily housed. So the aim of my talk is threefold. I have 3 key messages I'd like to convey, or 3 key directions I'd like to take. The first direction, or the first question I ask, is why human rights matter to pandemic reforms in the first place. So I want us to set up a baseline understanding of the linkages between human rights and pandemic reforms. The second is I want to do a very quick survey with you of what the current global health law reform processes are like, and whether they are adequately engaging with or addressing human rights concerns. And finally, having established that these global health law reforms are perhaps not engaging with human rights to the extent that they maybe should from the lessons we've learned, how can we advance rights differently in the international legal system more broadly? So those are my 3 key objectives, and we'll touch on these as well, and happy to also touch on it in the Q&A. But going back to why rights matter, I'd like to present 3 different scenarios to you, 3 different cases. Consider a teenage girl living in a busy South American district who is barred from going to school for months as a result of the pandemic and loses out on the ability to take final exams that would bridge her into a qualifying year for admission to university. She instead stays home to care for her younger siblings, while her single mom, who is a frontline worker, has to go and fulfill her janitorial duties in a hospital every single day during the pandemic. This young girl never goes back to school and never ends up fulfilling her right to education. Another scenario, consider that while South Africa was waiting to catch up to wealthier countries in the race to have access to a safe and effective vaccine, an entire township in Johannesburg falls to the grips of a new variant of the coronavirus, resulting in a death count so high that the peak surpasses any damage wrought by COVID in any previous wave. And finally, consider that in South Korea, robust contact tracing methods, which were arguably necessary in order to mount a robust response to the pandemic, ended up creating alerts that gave people an idea of and an awareness of the identity of people who were affected by COVID, and thereby exacerbated stigmas associated with illness that we've seen as a problem that comes up time and time again with HIV as well. What I want to impress on you in showing these and discussing these three different scenarios is that far from seeing these as siloed instances of human rights violations in times of a pandemic, we have to understand that they show just how interconnected we are in times of public health crisis. And that they also show this adage that we all have heard time and time again from the Vienna Declaration and Program of Action in 1993, the adage or the expression that all human rights are universal, indivisible, and interdependent and interrelated. What I just gave you in the previous slides were examples of civil political rights being violated or potentially infringed upon, of economic and social cultural rights being infringed upon, the right to education, for instance, and also extraterritorial human rights obligations not being respected because of a greed or a sort of voraciousness to get as many vaccines into one country as possible, to the exclusion of many other countries that needed those vaccines as well. The second underlying message in all this is that, and this is something we don't often hear in the being said during the COVID-19, that were said by our political leaders during the COVID-19 pandemic, is that health and human rights are inextricably linked. And what I mean by that, and what I mean by that term, is that when a public health emergency response or measure is mounted in ways that respect or promote human rights, the health effectiveness of that measure as a whole is much more successful. And on the converse side, when you have measures that are promoting our right to health, for instance, the rest of the gamut of human rights that we are all entitled to is also better respected as well. And this includes the right to health and the right to life being promoted in pandemic responses. So that's what we mean when we say that health and human rights are inextricably linked. This comes from 30 years of living and learning to deal with the HIV pandemic, and it's something that we should have also taken away from COVID-19. But instead, what we saw was that, and I think this is a message we probably all come to know very well, having heard from our political leaders. Instead, what we saw was that the measures that governments are implementing was always about following the science, right? This is like the kind of the term we all heard: follow the science, follow the science. And it's not so clear cut that that was necessarily the best message to convey all the time. We have some colleagues who've done some really great work in political science, in particular, Patrick Fafard, Margaret Macaulay, and others, who've really examined the role of chief medical officers and the adage or the expression of follow the science, and come to the conclusion that although scientific evidence does and should inform public health policymaking, policy decisions are rarely based on single inputs. Because real world factors such as time constraints, political values, interest groups, media, and public opinion are all routine considerations. And if we take a closer look at decisions that were made during COVID-19, the policy decisions that are purportedly following the science, whether these are public health measures such as travel restrictions, whether these are mask mandates, whether they're school closures or other measures that invariably led to some restriction of our rights and freedoms, we find that many decisions were actually not that scientific to start off with. Many were actually politically motivated. And although sorry, to take a step back, having this veneer of follow the science very often depoliticized those decisions and effectively shielded them from public critique and accountability. The second reason why it's important to look more critically, and it's important here to just for me to clarify that I'm not suggesting that science was irrelevant at all, but it is important to look and assess more critically what we were saying when we were expressing follow the science at a political level, is that the science itself was really incomplete. It was contested. it was changing as we were learning more about COVID-19, especially early on in early 2020 or so. So again, follow the science was a really maybe comforting message to hear, but the reality was a little bit more gray than black and white. And finally, I think this is where I want to land, is that pandemics, again, learning from HIV, start and end in communities. Even if following the science is one part of the equation, it is hardly the full story. And the other part of that story is that pandemics, in order for effective responses to pandemics to work, we must have trust, we must have buy-in from communities and from people who are the ones who will ultimately have to follow the mandates that are being put forward. And so when I was working with the Global Health Law Consortium in March of 2020, what became very clear to us as we were monitoring the early stages of the pandemic was that international laws and guidelines on rights-based approaches to public health emergencies were fragmented, and sometimes they were in conflict with each other. Sometimes they were also entirely vague on what the correct response was. For instance, international human rights law has very little to say about the precautionary principle, which is which of course we have come to know as being potentially a principle that was very necessary to follow in the early stages of the pandemic. So, and on the converse, of course, international health laws were very vague on how to really respect rights in times of public health emergencies, and also as a matter of prevention and preparedness. And so what I really want to say here is that responses to public health emergencies, yes, they must be evidence-informed, but also this was the other part of the equation which we missed, is that they must be rights-based. So now, shifting gears to looking at international legal instruments that we have in place today. The international health regulations are really the gold standard when it comes to an international legal agreement that governs how countries prevent, prepare for, and respond to a public health emergency of international concern. And within Article 3 of the international health regulations, of course, we have this one provision that engages with human rights and says that the implementation of these regulations shall be with full respect for the dignity, human rights, and fundamental freedoms of persons. And then in other parts of the international health regulations, there are provisions that deal with civil and political rights, but they don't explicitly call them this, right? For instance, the right to privacy, or the right to provide or to consent to, let's say, a testing measure. These are all things that the international health regulations deal with in a cursory manner, but it's never explicitly called as such. So the international health regulations, just as a sort of a segue to the reform processes we're looking at right now, are actually right now up for renegotiation and revision. 300 amendments have been provided to the international health regulations. That is essentially every single provision of the IHR is now up for grabs and discussion. And when you look at the article by article, and so just as a background, I was part of the expert review committee that provided recommendations on all those 300 amendments that were proposed. And I sat on that review committee as an international lawyer providing expertise to the WHO Director General and to member states on how to really reach sort of a technical assessment of these amendments in a way that would allow for better prevention, preparedness, and response in the future. And so when you look at these amendments, it's interesting to note that human rights is absent from inclusion in as an amendment in the process. Now, I will get into a little bit of why I think that might be, but if we had thought that the lessons learned from COVID should have been that human rights matters in times of public health emergencies, and we need to engage with them much more thoroughly at the international law level, that has not been the lesson that was taken away from the amendment process. At the same time as the IHR is being up for revision, there's also this process, again under the WHO, to negotiate a new pandemic accord. What is the pandemic accord going to do that the IHR doesn't do? Well, that's again a question that the member states right now are really grappling with. But perhaps, and one of the key areas or sticking points under the pandemic accord right now is, of course, access to medicines, and access to pathogens and benefit sharing. So the key pain point of COVID-19 being the inequitable balance or distribution of vaccines across the world, that is now being reflecting itself into the negotiation process. And that is some sort of the tension that states are grappling with. They have a timeline to finish this all off, I think, by the end of 2023, in order for it to go to the WHO Executive Board by 2024. And I think that it's actually right now up for debate as to whether they will reach that deadline. The pandemic accord did offer, because it was a brand new instrument, it did offer some hope for engagement with human rights within its sort of the various versions that we've seen of it so far. So in the zero draft that was issued in February 1st of 2023, there was, of course, this Article 14 of the pandemic accord that was entirely about protection of human rights. And I'm not going to dwell too much on this, but just to say, or just to point out that this provision, this Article 14 on the protection of human rights that was supposed to provide a balancing measure for states as they consider implementing public health measures. So it was giving them considerations on how to respect human rights as you implement public health measures. That is now turned into a Bureau's text of the WHO Convention that's under negotiation. And in June of 2023, if you look at the table of contents, the provision on protection of human rights is now completely deleted, right? Why? I'm not here to give answers to that because I don't know myself fully. But what I think is happening, and and I'm happy to have a discussion about this, is that equity is the term that's kind of taking up space, is the dominant term that we're seeing here today. Equity as a concept under WHO health equity. But international human rights law has a much longer history, I would argue. And the concepts and the norms of international human rights law have a much longer history under the UN, and also previous to the UN, than concepts that we are seeing that are a little bit more fluid, such as terms like equity, which can mean many things to many different states and many different negotiators. The other aspect of it, of course, is that there are so many pain points in COVID-19, so many areas where technically things didn't work, for instance, on surveillance or on access to medicines and benefit sharing, that focus on the normative, sort of the human rights dimensions of this issue is really falling from view as we're looking at really how to grapple with the real tangible problems that we saw during COVID-19. My argument, of course, is that human rights has a lot to say about those real problems as well, as are the arguments of many of my colleagues. But that is sort of the slippery concept of equity comes in much more to the fore because it can be used in different ways by different countries. And so this brings me back full circle to the principles and guidelines on human rights and public health emergencies. And in the main, the principles clarify, again, and affirm existing international law and standards that are applicable to human rights and global health, but they also build on existing expert consensus, which I'll get to in a moment. As I mentioned, they've been endorsed by legal practitioners, scholars, human rights defenders, civil society representatives, former special procedures mandate holders, and many others. And their development really spanned several years, and it was sort of a dialogic, iterative, consensus-building process that led to their development. The principles are an example of something that we're seeing, a trend that we're seeing in international legal scholarship and advocacy, which is to develop expert consensus on international law. And I will get into a little bit more of sort of the methods behind this, or who gets to become an expert and develop consensus on this. I think these are important questions to ask. But for a moment, let me just say that such expert consensus that doesn't come from states, that comes from potentially international lawyers, potentially doctors, potentially others, has three functions. The first function is that it can clarify legal obligations and raise awareness on how rights and violations can manifest. So they can clarify, but they can also consolidate international law on a specific topic. And so that is what you see, for instance, with the Syracuse Principles, the 1984 Syracuse Principles, which aim to provide a clarification of the of how the International Covenant on Civil Political Rights apply to national states of emergencies in particular. So the Syracuse Principles, again, was developed in 1984. It is now used and cited again and again by by scholars, by legal practitioners, by advocates, by negotiators of international instruments, and it has a sort of a value that goes above and beyond simply a document that you see before you. It has a normative value in and of itself. The second function, of course, is that it can help identify normative gaps in legal frameworks and bridge those gaps. And for instance, a recent development that I'd like to draw your attention to, but there are many others, is the Maastricht Principles on the Human Rights of Future Generations, right? So now we're at a point where we're being confronted by issues like climate change and global warming and the planet we're leaving behind for the next generation not being how it was originally and what that means for the rights of future generations. And so in 2023, experts came together to issue essentially the Maastricht, what they call Maastricht 4, because there have been many Maastricht principles, but the Maastricht Principles on the Rights of Future Generations. And finally, they can guide policymakers, they can guide advocates, they can guide academics, and provide robust reference points so that governments and those who want to hold their governments accountable have something to point to and say, hey, according to this deep assessment of the law, you are, for instance, violating or violating legal obligations that you have acceded to in treaties. And this, of course, has been seen with the Yogyakarta Principles being cited in judicial decisions time and time again. The Yogyakarta Principles are they provide a set of principles on the application of international human rights law as it relates to sexual orientation. Again, there was actually a decision just yesterday, I think, that was released in the Mauritius on anti-sodomy laws. It didn't cite, read the decision, I didn't cite this particularly, the Yogyakarta Principles, but judicial decisions, it did cite many other judicial decisions from around the world. And of course, that is an example of how documents like this or other cases that cite documents like this can become influential and really help change the law. From my own vantage point, sitting on the IHR Review Committee on amendments to the IHR, I also saw that the Republic of South Korea, for instance, in its amendments that it submitted to the WHO, it cited the Syracuse Principles as a rationale for why it had submitted those amendments, right? So here, for instance, it has said that the current IHR stipulates that health information, which refers to personal data, must be kept confidential and processed anonymously. And then it goes on to say that this is in accordance with the Syracuse Principles that were adopted in 1984. So again, an expert consensus document, normative value, it seems, and and there are plenty of other examples of this happening around the different sets of expert principles we have. And so this brings me to the Principles and Guidelines on Human Rights and Public Health Emergencies, which of course aims to achieve all three of the objectives I outlined. So it aims at a first point to clarify the law as it relates to human rights and public health emergencies. And so this is just a bird's eye view of the table of contents, but if you wanted to take kind of a closer look at the different sections and how it parses out, there's a section on definitions and concepts. For instance, it was crucially important to define what a public health emergency even is. That, if you can believe it, the definition of a pandemic is even right now highly contested as states are negotiating a pandemic accord. The second aspect of it is that it aims to identify a set of overarching human rights obligations and principles that apply at all times to public health emergency prevention, preparedness, and response. But the third and fourth and fifth aspects are, I think, where really the rubber hits the road and where it becomes very important to read the principles very carefully and consider how they apply to future law reform efforts. Because what the principles aim to do is to integrate human rights at all stages of the public health emergency. So at the prevention stage, at the preparedness stage, at the response stage, and of course, at the extraterritorial level in terms of obligations of solidarity that one country owes to another in times of crisis and in times of peace and non-crisis. And so that's the clarification objective. Of course, the identifying the gaps objective, I know I mentioned earlier on that international human rights law doesn't engage with the precautionary principle in a great level of detail. And of course, we try to engage with it, drawing on normative sources from other areas of international law that can actually help inform decision-making around whether the precautionary principle is something that should be carefully followed or not. We drew on UNESCO's definition of the precautionary principle. We drew on many other sort of the environmental law principle. We drew on many other sort of declarations, resolutions, legal documents to be able to come up with this, which I don't think I'll have time to go into, but to this. And so the final function, just to end off here, is around guiding, right? So guiding decision-making and policymakers. And just this past, which month was it? I think it was August or September, I can't recall right now. Anyway, the resolution of the Council of Europe's Parliamentary Assembly, Resolution 2500, cited the principles in 3 different parts of its resolution, right? So it cited it in paragraph 9.1.5, in which it called for a mainstreaming of human rights and potential amendments to the international health regulations, and in the drafting process of the WHOCA+, that's code for the pandemic accord, and ensure in particular that such instruments are in line with the principles and guidelines on human rights and public health emergencies. This was a majority decision. I think only a handful of states declined or did not vote for this. The paragraph 9.1.6 that called for a recognition that human rights are indivisible and impose clear obligations on human rights in the prevention of, during, and in the aftermath of public health emergencies in line with the PHE principles. And then finally, in paragraph 9.3.11, which I think, Errol, you might be interested in as well, because it called for a regulation of the activities of non-state actors and companies within their jurisdiction in line with the UN guiding principles, but also specifically in line with principle 5 of the PHE principles. So remember, this is a document that was released in May of 2023. So it hasn't, so by this, I mean the principles and guidelines were released in May of 2023. They haven't yet seen the level of usage and circulation that the Syracuse principles of 1984 has seen. But for instance, here it is already getting cited in multilateral resolutions. And so this brings me to this final point, which is that if we think that building expert consensus in international law matters, whether it is for public health emergencies, whether it's for the rights of future generations, whether it's for environmental law principles, whatever you wish to develop expert consensus on, then we need to develop a science, or at least some sort of framework behind it, because there's obviously a very real risk that who gets to sit in the room at that expert consensus table will not be representative. And so that's where I'll end off here, that my research explores the methodologies behind this type of expert consensus building. Because it has normative impact, because it has normative value, I think it also merits looking at it carefully to find out how to really craft these in a way that builds legitimacy on these types of principles. So thank you very much for your attention, and looking forward to your questions and comments. Thanks. Yes, please come on up.
Okay, can you guys hear me? Oh, it's all okay. So thank you very much for that really interesting presentation. So my name is Masud Husain. I was former Director General for International Law at Foreign Affairs, so I've been an international lawyer for about 30 years of my career, off and on. I want to tell you that, although I'm now retired, I want to come at this as if I were still in the office. If this were to come across my desk, if you were to do this presentation to me at the Legal Bureau at Foreign Affairs, and I will give you my reactions to this, so you may give you an idea of what to expect when you do come in front of states. Let me say what I strongly agree with. Firstly, I strongly agree that the current state of negotiations is blocked. The pandemic, what did we see? Very hard to find consensus, lots of finger pointing, a lack of trust in both domestic institutions and leadership, but also a lack of trust in UN and international leadership. So in that sort of context, how do you actually build consensus? And it strikes me that states are going to have a really, really hard time doing so over the coming years, because what we've seen in the international system overall is more and more difficulty of states getting to any sort of consensus on anything these days. So I agree strongly. I think this sort of ground up initiative actually has an opportunity to be very influential. I also agree that international law is very heavily siloed in many ways. And I can explain that a bit more from my experience. You know, when you're doing trade law, who's around the table? It's a bunch of trade lawyers and people representing industry. When you're doing disarmament, who's around the table? It's the military guys with JAG and the people that specialize in that sort of stuff. When you are doing environmental law, it's the environmental negotiations. It's the environment ministries with a bunch of hangers-ons, but very often very little involvement of actual foreign ministries, or less and less. So what you end up happening in these different areas of international law is you get silos of people talking in their specific areas and being very unaware of the other aspects of international law that they may actually be impinging upon, violating, or creating general principles that could then potentially be used in other areas when that's really not the intention. So the state of international law is quite difficult, and it doesn't surprise me that you have a bunch of health experts sitting around the table, that they are not integrating other aspects of international law, including human rights law, into their considerations. That being said, and I'll just mention another thing, just to say, again, these sort of documents can be very useful and very influential. I look at something like the UN minimum standards for treatment of prisoners as, again, a non-legally binding document, but is extremely useful and will have aspects of binding obligation, at least to the extent they reflect customary international law. But there's enough ambiguity in their status that they don't provoke a massive debate about each and every line. So let me now go into just what my critique would be. One is I would look at the principles, for example, and ask, what's your level of ambition for this? Part of that is, what sort of approach are you going to take? Are you taking a big tent approach, the idea that this should be global and cover everybody? Or are you taking a bit more of a club approach? Is this for a group of countries that want to sign on, have capacity to sign on, and you build it out? Generally speaking, trade and some of the others are more clubby. Environment is broad, big tent. And there's pros and cons to either side of doing that. I see a bit of the approach, both of those approaches in the actual principles. I think, again, there's some red flags that I would see to having this as being big tent. For example, there's references to democracy. Well, there's a lot of countries that aren't democracies, and they don't even self-describe as democracies. So having that as part of your principles in the document, they may feel that this is already exclusionary for them, and therefore they don't have to really pay attention to it. I think what I see as a big red flag that I would have seen as a lawyer for Canada would be the international solidarity obligation. Whenever you see something in a text talking about emerging principles of international law, you will have a debate about, well, when did that emerge? Where is it emerging? How is it emerging? And so for me, that would be the first thing I would put a big red mark over and say, hey, does Canada believe that this is emerging? Do we want to have this sort of obligation? Because the key thing from a government perspective, a government lawyer, is you don't fall into obligations. You negotiate them, you take them on knowingly, willingly, and tailored. And so, and I speak from hard experience when you're talking about precautionary approach, because I fought the precaution wars for Canada in international environmental law. And in all these negotiations, we were standing up, it's not a principle, it's an approach. And the content changes all the time. So the risk I see as if you want to move the principles into something more binding or in front of states is you are going to open up a huge debate about issues that actually aren't key to what you're trying to achieve, right? You don't want us to get into a huge debate about what's the meaning of solidarity or whether there's an obligation or not and what type of obligation, or, again, fight the precaution wars again, which we've done in so many other places, as opposed to the actual substance. Personally, I'm super practical. And let me just tell you then, my third critique would be, and this came out of my experience as DG during the pandemic, a lot of the principles is talking about internal behavior of states. Again, a typical human rights approach is, we all agree that we will behave this way within our states. But there are also aspects of that talk about the interstate relationship. But I can tell you from my experience in the pandemic, we were not looking at the domestic behavior of states. My key issues that I had to deal with were, first and foremost, and you might find this somewhat funny and arcane, but as a government of Canada, we had a duty of care to our employees. It was diplomatic law. Can you go to a diplomat who's coming into your territory who is inviolable and shove a Q-tip up his nose without his consent? Can you take that diplomat and send them into detention for 14 days against their will? Again, they're inviolable and they can't be arrested. So we were, and it wasn't just us, right? We were concerned about the behavior, about the treatment of our diplomats going abroad. And then we turn around and we see our own public health authorities are saying, oh no, that guy coming from that country has to get the Q-tip up his nose. Hey, he's a diplomat, you can't do that. Oh, no exceptions to the rules for this. So we actually spent a lot of time on those sorts of issues, partly because, again, as a foreign ministry, it was our duty of care to our own people, but it was then also getting back to fragmentation, trying to get our own public health authorities understanding that, no, Canada has international legal obligations in terms of how it deals with these diplomats, and you cannot behave this way. And we spent a long time trying to get them to understand that they, yes, you have to protect public health, but you have to do it respecting Canada's international obligations. The other thing that really came up, and this was a part of the policies that then got adopted, in association with closing the border. And that opened up tons of cans of worms, because then you had a whole issues of dealing with the United States. There was a bunch of implications about, okay, what do we do in terms of treaty obligations? How do we deal with somebody wanting free navigation passage? Because part of it is, no, we don't want you to pass through the waters, which is why cruise ships were stopped. Because if somebody gets sick and they have to land in a small remote community, then they're going to propagate the pandemic. So our focus was far more on these types of issues than it was on the domestic behavior of a foreign state towards its own citizens. And hence, we're not going to be talking about the human rights overall. It was going to be really, our discussion was state-to-state issues and how our treatment of each other. The other thing I would say about this is, finding the dynamic balance. Yeah, states have a primary obligation to their citizens, and particularly democratic states. They have to be seen as doing the best for their citizens. So it's what we saw. It was very easy to blame foreigners. It was very easy to hoard and stockpile. The whole principles, and I think this is where the equitable gets in, has to be balanced off with understanding that primary obligation of a state towards its own citizens. And what sort of argument do you end up having to say, oh, I have to deprive potentially some Canadians of vaccine to ensure that some other country can get some? And that is going to be a hard, if not impossible, call to make, particularly, and I think if you all recall here in Canada, the government was heavily criticized for being late to the vaccine game. And then it got heavily criticized for using the Novavax facility that was intended for developing countries. But the government was being as responsive as it could to its citizens. And this is good old Canada, right? This is good rules-based international order Canada doing this. My final point, and I'll stop here, would be just as I look at international law, and how we address the pandemic, part of it is you have to look at the recourse mechanisms. And from that perspective, because all of our hands were dirty to a large extent, because we were all taking measures that were violating other aspects of our international obligations, no one's going to go to the ICJ against each other. Nobody's going to go to the International Court of Justice to claim that you violated this convention or another by your actions. In fact, what we saw was a race to take the most restrictive measures, because once somebody closed the border, everybody started asking questions, well, why aren't you closing the border? And so you just saw a cascade of harsher and harsher measures. that everybody adopted, even those that tried to do, will have herd immunity, will keep things open. Sweden, Boris Johnson early on in the UK had to change because of just the domestic pressure of what are you doing when everybody else is taking much harder measures. What's your either science-based approach for not closing? What's your precautionary approach for, taking more or less measures? So from what I saw, there was absolutely zero recourse in international law coming out of the respective measures because we all ended up having to do things in an ad hoc way vis-a-vis our obligations. So those are just some of my reflections. I think, you sort of go back to what does international law help? I think this sort of document will be helpful because it gives you a good one-stop shop. But my fear is that the progressive nature of some of this will just end up in a debate among states about things that are actually not critical to what you're actually trying to achieve.
Thank you very much. So I'm the moderator, and my role is to basically try and get some discussion going based on the presentation by Roojin and Masud. And so I'm going to start with Roojin, but before I do, I want to say how pleased and privileged I am as a colleague here at the faculty to have Roojin as a new, relatively new colleague at our faculty, having graduated from our own French common law program, and already in the time between being a graduate of our faculty to now being a professor, she has had a huge impact on the world already. How many of my other colleagues can actually come close to that? So congratulations, Roojin, on that point. So in terms of the comments I would like to get going in terms of discussion is, Roojin, you mentioned that some of the roadblocks that you're having is because now the focus is on equity as opposed to actually talking about human rights. Is there some way to deconstruct that? Because one of the main professions that people were making when the pandemic happened was, we're in all it together. No, that wasn't true. That was not true in any way, shape, or form. We were not in it together. Try and ask that question to those who died and the families of those who died in the long-term care facilities, our biggest fatality during the pandemic. Even today, there is still allegations that there was almost negligence, possibly criminal negligence, in terms of the failure to do the proper inspections of the long-term facilities. Likewise, when you look at some of the frontline workers who were usually the poorest, the ones who are most vulnerable, a lot of them visible minorities who had to go to work despite the pandemic, and lo and behold, there was no payday, no sick pay for days off. So what we're seeing now underlying this notion of equity is the fallacy and the hypocrisy that it fails to understand human rights underneath this. And so one of the things which I think you focused a lot on your presentation on human rights principles, human rights conventions, etc. Is there a way you can deconstruct the approach to equity and try and bring how underlying that approach to equity is the failure, the massive failure of the underlying human rights obligations? I don't know whether you want to address it now or later. Up to you. Okay. Yeah.
Thanks so much, Errol. And yes, in the principles, we start off from the outset with a definition of equality. And we break it down into the parts that we know that have been established in international human rights law already. So we have formal equality, right? Substantive equality, even transformative equality, the concepts that have been advanced in the various treaty bodies that we have in Geneva interpreting international human rights treaties. But the concepts of human rights, I think, give us a lot more to critically, systemically parse what happened during the pandemic. Because, of course, you had civil political rights violations, which included things like right to privacy violations, but also right to movement or freedom of movement, freedom of assembly. And all of these have within human rights law documents that allow us to sort of understand the proportionality aspect of it in times of crisis. Civil political rights aside, we had economic, social, cultural rights violations. So we had, right to education, a right to livelihood, right to health even being violated, because of course health is far more than just preventing or being protected from a pandemic. It includes sexual reproductive rights access. It includes many other things. So the principles really get at this concept of when we say the human rights are interrelated and interdependent. COVID affected all of them. It virtually affected every single human right we know that has been enshrined in international law. But more than that, COVID affected solidarity. And I think that here we are getting at an emerging principle of international law. But the thing about these types of consensus building initiatives is that sometimes they have diverse audiences that they address themselves to, right? And so with emerging principles, of course, someone who's steeped in international law as a government practitioner would rightfully view that with a degree of hesitation. But let's say an advocate who is incredibly effective at getting their government to see the value of solidarity might get the Ministry of Health, for instance, or the trade, or the ones who are making trade decisions at WTO, might make them see things differently. I'm not saying that happened, but these are these types of emerging principles also are crucially important in international human rights law. And so when we're talking about equity being kind of the term that's used constantly in these domains of the WHO, we lose that granularity and that I think that clarity of thought and purpose around what we're trying to achieve in the pandemic accord. So I hope that answers the question. Yeah.
Actually, one of the reasons why I actually focused on that was I'm wondering whether when you're going forward on the principles and trying to get it included in the regulations or the pandemic, is to actually make the statement that underlying equity is the fundamental obligations of human rights obligations under domestic law, as we now know in Canada, where so many of the human rights challenges were apparent, and under international law too. So that could be a way of trying to progress it too. I do want to turn to Masud and try and ask to do a critique of your critique, if you might. You mentioned that oftentimes to full disclosure, I was involved in the development of the UN Global Compact, which then led to the UN Human Rights Principles. And we faced all the similar types of criticisms that you mentioned in terms of Roojin's principles at the same time. But the one thing which kept us going was to understand that you never know when some of those principles may actually end up being incorporated, not maybe at the international level, but maybe one state will say, we should think about this and we should try and incorporate it. And so now when we see how what we thought, and many people told us was a fairy tale that we were creating, now has emerged into domestic legislation, build on the Global Compact, build on the human rights principles. And now you have France having a hard law in terms of due diligence. You have the Netherlands the same way. You have Germany doing the same thing. And guess what? The monster of them all, the European Union, is about to come out with its own directive. So it's sometimes you fail to see in advance what these aspirations, if you could call it that, or this hopes that you may have at a certain stage could slowly, it may take decades, but at some stage, you never know where it could end up going from soft law, which is what the principles really are, to maybe a sort of a harder form of soft law, if you can call it that, and then potentially moving into a hard law, as is now apparent in the area that I teach, which is corporate social responsibility, human rights, the environment, etc. And even on the environment, you mentioned the precautionary principle, approach. You well know that even in the most contentious area of the environment, we've had a trade panel in a dispute between Canada and the European Union apply the precautionary principle, which could now be the basis of actually moving forward, perhaps even in the health law regulations too. So I'd love to know your answer to my critique of your critique.
Thank you. And Earl, listen, I don't disagree at all on the importance of soft law and how it is possible for soft law to transition into harder soft law and ultimately into hard law, whether it's done in a treaty format. There can be a lot of frustration with it too. You know, the International Law Commission produces some very good work, and some of it is reflective of customary international law that gets codified, and some of it is more law development, which states push back on. So you can so I think my word of caution is more, what's your level of ambition, what's your expectations and hopes? It may be parts of this can very easily get taken up and moved into a harder law. There's a wonderful institution in The Hague, by the way, I'll make a pitch for. Sam Mueller's the Hague Institute for the Internationalization of Law. And what they point out is that as domestic law sort of influences each other, that's actually a source of international law over time, as France, then the European Union, then others start adopting measures that make it much easier for them to say we could also internationalize this either directly in treaty or by courts referencing other court decisions or the existence of these things. So I don't dispute whatsoever the importance of soft law. It's why, as a government lawyer, we fought it so much. I mean, why do you think at the UN we're arguing over all this language and resolutions that themselves are not legally binding? It's because we understand that they're soft law, they're influential, and over time, somebody says, well, why did you agree to it? Why did this pass with consensus? What is Canada's view on this paragraph if you've allowed it to go forward? So yeah, we fight some stuff tooth and nail to avoid exactly having things that go contrary to, in our point, Canada's needs and expectations for international law.
Great, thank you. Now, I'm not sure whether we have any questions online as yet. Is there? Any other? Okay. Can I encourage those who are online to, if you want to do a question, I gather you can do it through the Q&A. Is that correct?
Yeah, or the chat.
Or the chat. So we'll give you some time, and I'm going to keep on asking more troublesome questions to my colleagues here. To you, Roojin, in your principles, there is a substantial chunk devoted to the obligations not only of state but what you call non-state actors, and this goes back to the issue I just discussed in terms of non-state actors. When we see, for example, the appalling behavior of the pharmaceutical companies, where it's now clear that they were basically shortchanging countries and even giving different pricing for different vaccines, et cetera. I mean, obviously, South Africa in particular, which had one of the gravest, as you say, in one of your scenarios, was the most affected. They were actually charging too much in comparison to other countries. Is there some way in which your principles can tease out how that can be followed through, even if ultimately all your principles are not adopted by the WHO? Is there a part of it which, given this appalling behavior by these pharmaceutical countries, at minimum you could try and insert some action item that the WHO must follow to basically go through and say, look, this cannot keep on happening, because what happens in the next big one, which especially if it's focused primarily on Africa, where from the record now, the horrendous victims of this multiple pricing strategy were African countries and some Asian countries, but I think Africa suffered the most. Is there some way in your principles going forward you can focus on that particular horrible inequity to then get the WHO at least to do a follow through that? We're now seeing, based on what I was just discussing in my critique of Masud, that we now have hard law in some of these countries where if companies are actually misrepresenting or actually just falsifying what they're doing, there could be penalties, financial and possibly even more than just financial. So is there some way in your principles you can actually think about how do you focus on very important non-state player in the regulations. I'd love to know what your thoughts are on that.
Thanks a lot, Errol. That's so the non-state actors and regulation and of non-state actors comes up throughout the principles at multiple points. It comes up, non-state actors come up, first of all, in the overarching set of human rights principles, but then trickles down into the extraterritorial obligations, of course, of monitoring, right, transnational pharmaceutical corporate activity. It doesn't say pharmaceutical corporations in particular, but I think we have language or words to the effect of the manufacturers of health goods, products, and delivering of service and that sort of thing. So we do try to create sort of a more specific set of obligations applicable to states regulating these actors and to these actors themselves, recognizing that there are limits to what you can ascribe to non-state actors. But what is really interesting, Errol, is that even at the IHR review process, there were discussions at the time of whether we can insert within the IHR obligations to regulate non-state actors for a variety of purposes, including potentially for pharmaceutical corporate managing that sort of entity for equitable access to vaccines and medicines. And the argument was, of course, that the IHR applies to states, doesn't apply to non-state actors. But when you read some provisions of the IHR, it addresses itself to conveyance operators. And so there are these these insertion points where you can integrate obligations of regulation of non-state actors within the IHR. And if they are there, then we should definitely build upon them in the legal commentary to the principles. So that's one of the things we aim to do, is to address the context of South Africa. Of course, there are vaccine procurement contracts being made transparent fully on the basis of a court decision recently. And to use that case as an example of why it's so crucial as a human rights, as a matter of a human rights obligation to make vaccine contracts or any kind of public health countermeasure contracts fully public and transparent. So I think it's just exciting as well that we see the same discussion happening at the IHR table, so that it's not just lofty aspirations, but it's also becoming even something that is integrated in that instrument.
Roojin, actually, playing my usual troublemaker role, one of the things which, in my dreams, I was hoping that some shareholder, I'm actually going to check if I am a shareholder of any of these pharmaceutical companies, there could be a really interesting class action lawsuit against these ones for misrepresenting, because under securities law, I'm sure they've misrepresented what they were doing when they were shortchanging certain countries and not others. So for anyone who is a shareholder, maybe you should think about that. But anyway, building on some of these issues, which are the most controversial, one of the areas, and going back to Masud's critique, you're absolutely right, Masud, that in the trade law area, for example, since the very beginning of the global trade rules, starting in the Bretton Woods meeting, it was dominated by economists and trade lawyers, and that's the reason why, right up to the present day, we're still grappling with how do we then deal with human rights, with the labor rights, etc. Is there a way? I mean, and this is asking you to sort of a critique of your critique and coming up with solutions. Is there a way, based on your experience as a high-level negotiator in these things, where you can push people out of their silos and say, and how do you do that by bringing other peoples in the silos? I was thinking, for example, one of the spectacular successes of Canada, everyone's saying how badly we are now in international, but we forget we've had major successes, and the one which I'm very proud of, as partially involved, was the mine treaty that Lloyd Axworthy pushed. Even though he had criticisms even internally for pushing it too, he managed to push people out of the silos, the defense industry, etc. How did he do it, and why can't it happen in this area? I mean, do you have any knowledge of that? I mean, I had glimpses of it when he said, I'm not going to only talk to military people. I'm not only going to talk to defense. I want to talk to people who actually have seen these mines blow up and take off limbs of children, etc. And that was massive success. So he did then. How could Roojin and work with others to do it here in this area?
I mean, it's a great question. And again, I don't want to be the voice of doom and gloom. I would say that period was a very different period, right? At the end of the Cold War, there was a new sense of opportunity, and we got landmines, and there was this idea that we were going to have this NGO government partnerships across different areas that we hadn't done before. And I can tell you, because I was deputy director for environmental law, international environmental law, we set up committees for trade and environment within the foreign ministry so that our trade law guys and our environmental law guys and the policy branches were talking to each other, partly defensively, to say, okay, what are we doing, and make sure we're not doing something on one side that's going to hurt us on the other. At least we're aware of what's going on. So that sort of coordination did happen and does happen. But I think, as you start going through, the more you open it up, the more you try to umbrella it, the more players you've got to get involved, the more labor intensive it gets. It's hard within government, and particularly if you move into a declining resource area, that getting people to have the time and focus and energy to try to do new things gets very difficult. So again, the broader you go, the more players you get, even within government, the harder it is to come to some sort of position and coordination, right? So I'm not doom and gloom. Lloyd Axworthy did it in a very specific time and place. 9/11 hit, and we went back to hard law. And this whole public partnerships that we were seeing in the 90s really dissipated as we ended up into a much different type of world. We are moving into a different world now. There will be opportunities in, I think, niche areas, but whether health is going to be one of them, that's a good question. I'm not sure.
I wonder if you could pass it over to Roojin.
Yeah.
To talk about whether this is a possibility of pushing people out of the side.
Yes. So this is such a developing issue right now, I think. I was just reading this morning a blog post by one of the civil society advocates who attended the UN high-level meetings. I think it was in mid to late September. One of them, of course, being a draft declaration that was supposed to be developed on pandemic preparedness. And a total of, I think, 15 countries spoke at that UN high-level meeting, which, I mean, of the more than of the dozens of countries that should have been there and should have had some interest in this topic, none were, it was largely a silent procedure and an absent sort of absent from those discussion tables. I think that there's a bit of a pandemic fatigue right now, but COVID should have had the same reckoning. We should have had with COVID the same reckoning that we had with 9/11, I think, and that is the tragedy of it, because maybe we lost time in the process of negotiating two different international law instruments on pandemics, so the IHR revision and the pandemic accord. It might be that dual track process was flawed, but I think that there's just sort of this, they've lost the plot, really, is from what I'm seeing, and it's exhaustion and just things are moving on as well, and artificial intelligence has taken up so much space. The news cycle has moved on, and so have governments, I think, sadly. But that is where things stand right now. But so this is my one remark about this as well, just to it's not positive, it's not a good thing. But it is a fact of life that pandemics will, and even if not necessarily a pandemic per se, from the terms of the definition of it or being scaled around the world, public health emergencies are a fact of our existence in this globalized world. And we're going to see another outbreak soon, whether that's a WHO-defined public health emergency of international concern or not. It is almost certain we'll see another public health emergency of international concern. Pandemics are also highly likely. I think that's when these types of documents, Errol, come back into full view for everyone. Right now, I'm not too bothered that if we even get like a Council of Europe Parliamentary Assembly resolution citing to the principles, I would consider that a win. But I think that in the key moment will be when we see these principles actually getting used in the next crisis, or being used in the next kind of drive to build pandemic preparedness. That's really when that's really when the value of this type of work will come out. So it's okay to be a little dormant right now too. Yeah.
If I could just say, and I think again, I start with level of ambition. If you believe, as some do, that we're into a globalization period at this point, with maybe the Americans pulling back from the broad reach that they've had, then maybe you start looking, instead of big tent, maybe the approach is better codes of conduct within regional, again, whether from a Canadian government former Canadian government lawyer perspective, code of conduct between Canada, US, and Mexico, for example, the NAFTA partners. How should we behave to each other during a pandemic? How do we deal with freedom of movement and our supply chains? And starting from there, move it out into our neighborhood, into our broader region, as opposed to trying to take a big bite out of it at a global level, right? It might be a lot easier. And this is, again, where some of the principles in the, some of the elements of the principles could be very helpful. But I agree 100%. I think we're in pandemic fatigue, and things have moved on, and people don't want to talk too much about this stuff right now.
Yes, I'm quite aware that there is pandemic fatigue, even when with my students in my other classes, whenever I use the word, say, oh no, let's keep it away from that. But we can't, because I mean, you correct me if I'm wrong, there's some experts who say there's about a dozen zoonotic type pandemics which could follow in the next one. And for us to say that it's game over is stunning. But given that, I mean, when you look, for example, at even now in hindsight of, well, it hasn't gone. The pandemic is still with us, as we know. The rates are rising in Ottawa. But even now, there is a part of our Canadian community which still thinks that everything that the public health regulations did was wrong, that it was a violation of their human rights. To me, I think that is a big issue that we have to confront domestically, and potentially even internationally. It's interesting that that even now there is apparently another so-called trucker convoy starting to materialize in Toronto, apparently, or others than that. And if that keeps on happening, is there going to be an even bigger suspicion of any application of human rights principles to the dead? But when you have people who are basically ignoring what human rights fundamentally are all about, despite the fact now that we have at least about 4 or 5 major decisions by courts across the country, which says you can't just decide on your own that you have an absolute right to freedom of association or freedom of liberty to do whatever you want, if what you do is going to affect, the community or your institution, whatever. Is there some way in which this debate that you mentioned, and which is a core one, into how do you sort of merge this interest of science with human rights, and get people to understand that it's something which it really has to be discussed and belong to the entire community, not to one person's assessment of what human rights in the pandemic is all about. That's, I think, going to be a major struggle, even now in the aftermath, because, as I said, they're still they're still saying that their human rights were violated. So how do you address that?
Thanks, Errol. That's an excellent point. And the thing I would have to kind of that I would flag for us as something we have to develop is advocacy toolkits on the basis of the principles, because they're right now extremely dense. They're I've seen them being shared a lot on Twitter. Sometimes I wonder if they're being shared for the right uses or purposes, because it's a set of principles and guidelines on human rights and public health emergencies. And messages from the truckers convoy were all about human rights, right? The messaging was all about human rights. So I think this notion of raising awareness, of educating, of making sure that we are all aware of what we're talking about when we talk about human rights is a huge project and a huge wing of the work that the principles need to achieve, in addition to being kind of amenable to government policymakers. The real work might actually be to make them kind of amenable to the general public and understandable to the general public. So absolutely, that's one of the things we want to take care of in the coming few. And depending on funding, that's stuff that we want to lead. There's a documentary coming out about the principles, so hopefully that will also help to create some sort of awareness of what they are. Yeah, I think I'm drawing a blank right now. I had another point I wanted to make about this. Yeah,
I wouldn't mind
sure.
also addressing that point, because I know that governments were very concerned as to how you're going to manage this next time around, because no one, not right up to the Prime Minister, doesn't think they did a good job in terms of trying to get the message out that you can't just decide what your freedoms are in the absence of other people's interactions with you.
Well, I think we go back to lack of trust now, lack of trust in government, lack of trust in the scientists, in the medical community. Dr. Fauci has been, attacked mercilessly in the US. And, how do you make decisions in the context of not having perfect information with lots of scientific uncertainty about origins and how to deal with it? What struck me and what strikes me a bit in the principles is the non-discrimination. Because I think this is, again, an area where application is going to be almost impossible. I'll give you the example. If you see that the death rate is highest amongst elderly and the infirm, do you shut down everybody? Do you take away the rights of the able-bodied to go to a discotheque in Sweden just so that, grandma can go to the store? Maybe you do, and maybe you don't, because what's the able-bodied young person to say, well, I'm not very much at risk. When you look at the risk factors, I might get sick, but I'm not going to die. I'm probably not going to show up in the hospital. It'll be these people. So who do you lock down? If you're going to say somebody needs to be locked down, should it be the elderly and the infirm? What about their rights to participate in society? Do you shut down everybody to protect some? There's no good answer to this stuff. And the pandemic didn't give us a good answer, because I think, we came out with now huge skepticism about any measures, let alone, limited measures, and how that would be faced on the basis of non-discrimination. You say, well, why am I locked down and not you? Or why is everybody locked down when I'm not particularly at risk? This is what governments are going to have to grapple with, and how they were able to articulate what they were doing, and then again, the different approaches. And I'm seeing some stuff online now saying about Sweden had a much lower death rate overall by not having a lockdown. So, man, it's a hard call.
We have a few minutes left for this session. Perhaps I can ask someone in the room if you have any questions. No?
There's one in the Q&A too.
Oh, great.
I think that's my question.
Oh, that's you?
Yeah.
Just want to say it then?
Yes, go ahead.
Okay, so as much as we like to take into account, sorry, let me just reread it back here. That as much as we do want to uphold human rights, it's very difficult when you have competing factors such as keeping a population safe versus keeping an individual safe. So how can governing bodies really make sure that even though they're implementing strategies, that these strategies are not overstepping their responsibilities to keep individuals safe while trampling on their human rights?
Yeah, so this is I think the $1 million question of the principles, right? Is how do you balance, because they address themselves to public health emergencies, right? How do you balance public health, the collective right to health, right, to against individuals right to an enormous number of things, including right to move around in their in their hometown or wherever, to between countries, between provinces, and that sort of thing. The principles try to integrate. They don't give you, I would say that, like I think Masud really alluded to, there's no right answer if you read the principles. There's no sort of this is the only course of action that a government should take, but it provides a set of considerations that would hopefully make the decision a lot more informed, a lot more rights-based, and ultimately protective of the right to life and the right to health. So just very quickly, just to give you some ideas of one of those factors, one of the key things that we've, I think, failed to integrate in the pandemic responses is public deliberation processes, right? Social listening processes. How do you read the room, right, of the public that you have? Read the room and understand what their capacities are, what they're capable of dealing with in terms of a mandate or a lockdown, right? How do you engage in public deliberation processes that solicit views from minorities in the group? And on top of that, as well, understanding really firmly, and this is an understanding that ministries of health and public health officers need to have, really firmly understanding what are international human rights law obligations that Canada, for instance, has acceded to, because these are treaties that a federal government has decided to join in on, and they very much have implications for people on the ground in the provinces as well, and in their local settings. So these are kind of different types of considerations, but they're there, and they're kind of more cogent, more articulate for the policymakers and the decision makers who have to decide on measures during public health crisis. But one key thing I will end off on is that in addition to providing a set of considerations for the response, I think the bigger picture is about preparedness and prevention. And if you have, for instance, a country that takes away the lessons of, we haven't done a national inquiry here in Canada, but if you take away the lessons, if you do an inquiry, take away the lessons, integrate policies, legal preparedness measures well before the next crisis arises, then when that crisis does arise, because we know it will arise, the countries will have to take measures that are hopefully less drastic, less infringing on rights. And so it's like a cycle. It's not just about the immediate response.
It's like a feedback loop, like a growing.
Yeah, and the less prepared you are, the more likely you will be to have to take measures that infringe on rights when the crisis arises. Yeah.
I think that's right. Yeah.